The 10 o'clock calendar, we have post-judgment proceedings. The case number is D519168. Looks like we have the parties present. Counsel, please keep on the cards.
I'd like to for the plaintiff on procedure for post-judgment present. May I state your name, please?
Danielle Tyra.
Ms. Tyra, the court decided this matter with findings in order. You filed a motion to set aside the order, and that motion was opposed. That's what we're here for today. In addition to what's in your paperwork, is there anything else you want to tell the court?
Absolutely. I have 2 CDs here to prove that. I'm sorry?
I'm waiting.
Okay. I have 2 CDs to prove that I have not been calling and harassing anybody. You won't find my number calling anyone. I got the 3 numbers I do know on the CDs I got from February 1st until March 20th on these 2. And I would like to, these pictures, my son was bitten by a dog, his hand. And I have the proof of the pictures right here and the text that Jason sent. The dogs that he's got at that home aren't child friendly. The day before they were playing with the dogs, he said he did it from a tree. And these pictures will show another, it's pretty bad. My son wanted to go to the doctors. Jason, his hand was hurting. There's green up his hand. You can see the clear bites right here, the holes in his hand from the pictures. Can I hand you the pictures?
No. Actually, your request is essentially asking the court to reconsider its order that was entered after the evidentiary hearing, not to introduce new evidence.
Oh, okay.
Now, stop, listen to me, okay? If you cannot persuade this court to essentially revisit the findings and conclusions, your options are to essentially appeal to the Court of Appeals or the Supreme Court, alleging that there's either insufficient proof supporting the decision or that the court has abused its discretion somehow in entering the order. That's what your rights are, okay?
Okay.
Now, arguing stuff that happened since the decision clouds the issue a little bit because the court can't reconsider or set aside the order on new evidence. The court retains jurisdiction throughout the minority of the child to deal with changes in circumstance. We know what that is because you have been before the court several times on evidentiary proceedings, the initial trial, and then the most recent evidentiary proceedings. So you know that things that happened since the last custodial order are part and parcel of the continuing jurisdiction of the court. You need to focus your comments on the request to set aside the order. Okay. Now, in your papers, you basically say that the court should set aside the order because the documentation concerning absences was mistaken, right?
Yes.
All right. Now, they filed an opposition and said that either before or after the evidentiary proceeding, or after they obtained the documents, you went to the school district and you had the records changed to show that many of those absences were excused, right?
No, Your Honor,
well,
that's not
right.
right.
I just want you to respond to that allegation because you didn't reply to the opposition. The opposition was filed on March 15, 2017, and in that was one of the points that you made. Is that right, Mr. Root?
Yeah.
All right, so I'm giving you a chance to make a record concerning what they've alleged as far as, because obviously the court explained in a written decision what the basis was for the change. One of the factual findings was the issue of attendance.
Yes.
Since the last custodial order. They, in their response, have said that the evidence, it was authenticated, but that something changed around the time of the hearing or after the hearing related to those records.
Okay, Your Honor, I have on 1/30, this is a conversation with the principal, 1/30/2017, about the absences, me asking her. I got the correct in the actual. I actually don't know how he got the attendance log that he got. I got an attendance log 11/2/2016. The attendance log he turned in was 12/2/2016, and it looks nothing like the one I got 30 days prior to the one he obtained. That's where I'm questioning, did he falsify it? Because I never seen an attendance log with all of them verified absences, ever. And the one I got 30 days prior to his didn't even look like that.
Well, you know that that wasn't the only reason why the court made a change. And like I said, I respect the process in that you have a trial court that hears the evidence, you have a trial court that explains its decisions in an order, and then if you either believe that there's insufficient evidence supporting the decision, or if the judicial officer abuses discretion in making the order, then you have a right to appeal, okay?
Yes.
But as far as setting aside the order, I didn't take it off because I wanted you to, number one, be able to make record and be able to tell the court
Yes.
the reasons for that.
Your Honor.
And then also, I wanted you to be able to respond to the opposition, which you didn't respond to, which goes to the
You-
one of the critical issues in this case, which is whether or not this issue of educational neglect was supported or not supported by the evidence.
Okay, Your Honor, I did respond, and actually, I left all the papers under his door at his office. I did respond.
When did you file your reply to the opposition?
That was the problem, I didn't file it. I didn't file one paper, and that was where my biggest mistake was.
When
I
you filed the motion, okay. Is there anything else you want to say before I hear from Mr. Reed?
Yes, my son, he is, I got all the records of his testing. I got the paper that I handed Jason out in the hallway of the testing that the school district did. My son has a section 504. I got his, where they specifically detail the situation. And also, my son is just wanting to come home. He is, his hand got bit up by a dog. I'm not supposed to discuss that stuff, okay. Yeah, it's in plain error. They just filed an answer on Thursday, which was the 16th, I believe.
15.
3 days before court. I mean, that right there should be default. I think that's correct. This whole time, and they just now, 3 days before court filed.
Well, that's one of the considerations that the court weighed in allowing you to orally respond to their response, which is this notion that you went and had and effected a change in the school records since they were obtained by the plaintiff. So that's one of the reasons why I didn't say you cannot respond to that allegation because of the timing of the opposition.
Also, the principal of the school left a note, a sticky tab, and I turned that in as evidence, and the original. She informed the attorney that the absences were under review for changes that should have been done a long time ago. I've been in a battle with the school district for a while, but as far as my behavior with the school district, both of the due process hearings have been reversed. So we're doing another due process hearing because they were in error of dismissing all of that. I'm not in any way combative with the school. I'm sorry about that. Yeah, it's all in plain error. It was falsified, absolutely. The attendance was false. I don't neglect my son. I never have. I never neglected my child. But he was informed, and he still went ahead and told you that that was the actual attendance, which it's not. I have the actual attendance right here with me, and they weren't made after the court date at all. This was done before the court date, which is why I believe that they falsified the attendance log, because I have an attendance log 30 days before Jason obtained that one that's dated, and it doesn't have all the verified absences.
Well, does it really matter to you whether the absences were verified or unverified when they're in the number that was reported?
Well, actually, yeah, because if they're all unverified and no good reason to have your kid absent, yeah, that's absolutely neglect. Every single one is circumstantial or medically excused, and my son's blood pressure, and I turned in a blood pressure log from the school, they would call me to come get him because his blood pressure dropped, and it wasn't because of the medication. It was a 2-month process with the pediatrician. We went from 4 milligrams of clonidine down to 2 milligrams as a precaution to be certain that it was not. I stopped giving him the Intuitive in the morning, and I gave it to him after school, and he was still falling asleep. So we know now that it's not the medication. I was doing everything strictly under the pediatrician's orders. Then I would have to take him to his medication doctor, and that's what added up all the absences.
Well, you read the order, right?
Yeah, I did. I was able to.
So you know that the court talked about the problems with custody exchanges since the decision on the trial. The court talked about the issue with you posting on a school platform a threat to the teacher that resulted in you being kept from the school,
Your Honor,
which also coincided with the absences of the child. So you're going to have to address with the appellate court what pieces of the findings and conclusions you think are error.
Yeah, the reason that they trespassed me off of the school property the teacher was ignoring my son falling asleep, okay? And I called the school police to come with me. And yes, I was angry. My son, his blood pressure was dropping. She was ignoring it. Nobody would do nothing. And I mean, I didn't show up at the school yelling, screaming, throwing a fit. I brought the school police with me. And that's why I was trespassed off the school property. Yes, I did say the words, you know, if you know, I don't want to say it here, but.
You don't have to.
Okay.
Because the communication was admitted into evidence, was it, Mr. Root?
Yes, sir.
And I did submit 700 papers of evidence, but this is really harsh. My son, I mean, he's not being treated properly. My son is a special needs. He is very mean to him. He doesn't let me talk to him. My son, he hung up the phone on the middle of me and him talking. My son was crying. This is wrong. This is wrong. It's definitely an error, and all because he falsified an attendance log. I mean, if anything I ask is to please let him take me back to court. Let him take me back to court with something that is not falsified.
Yeah. Mr. Root, what points do you want to emphasize with the court?
Your Honor, the court reads everything. The court sees the affirmation the child is doing fine. He has doctors, he has dentists. He hasn't missed a single day of school. He loves California. What is disturbing is she texts my client 35, 40 times a day. And the court read that on February 20th, she didn't even tell him that there was about the change of custody. He was going to have a different place to live. She didn't have him packed, not his medications, not anything. And every time she talks to him, she tells him he's coming home, he's coming home. I'm going to jail. Mr. Vanburen's going to jail. Everything is crooked. Not just the school this time, but the court, me, him, everything. This is the impossible situation she's laying down, which is why I asked that he's also, of course, he gave her weeks before the names of the doctors, and she's calling up the doctors. She's harassing the doctors. She isn't at all complying with your order, and every time she talks to the boy, she's upsetting him because she's telling him, you're going home with me, you're going home with me. I don't know what to do about that, Your Honor, other than just to have her call once a week at a particular time and not say these things.
Well, the difficulty in this case seems obvious, and that is that it goes to trial. The court made findings a year ago concerning all of the pieces of the upbringing of this child. And the court concluded that mom would retain custody, even though a lot of these themes were advanced in the case. And I feel the trauma to mom in losing physical custody of the child in this decision. I mean, I get it. I understand that from her point of view, this is not in the best interest of the child. The court issued a custody order that changed the physical placement, but didn't eliminate mom from the child's life. We have 3 months a year of contact on a periodic basis. Ms. Tyra is at risk of, making decisions or doing things in the case that could threaten her ability to have that meaningful relationship with the child. From her point of view, the court should undo the order. From her point of view, she says that there's insufficient evidence to support the findings and conclusions. In this particular case, because of the special needs of the child, because of the facts and circumstances of this case, I took care in the original instance and then in the recent evidentiary proceeding to write out all the findings and conclusions of the court to explain what the reasons were. So anybody who looks at this case, in addition to the record, which would show the testimony and the other evidence that was considered by the court, there's no question as to what the court based its decision on. And if an appellate court determines that there's insufficient evidence to support the decision, or if there's an abuse of discretion, then the court will be advised that the matter should be revisited. But there's no basis based on the filing to set aside the order. While I understand mom's sincere point of view that the court got this wrong, it doesn't matter. This is the court made its findings and conclusions and she'll follow the order. Mr. Root, you're directed to prepare the order. The matter will be closed and she should exercise her rights as directed by the court.